So that is how we have to deal with regard to the rejection of claim under Order 7 Rule 11. Now, coming to our point. When such an application is filed by the defendant, if the court allows that application, it becomes a decree. Suit will be, claim will be rejected because our section 2 subsection 2 says an order passed rejecting the claim is a decree. Therefore, an appeal is provided. On the contrary, if the application is application is rejected by the court below. So then the defendant has to challenge that. He is approved by that order, rejecting his application. It is not bar. It will not accept the view of the defendant. It will not attract Order 7, Rule 11, D. If he takes up on any other grounds, So, court naturally, Order 7, Rule 11 further says, the plaintiff can also file a fresh suit. The plaintiff can also file a fresh suit on the same cause of action. That is what Order 7, Rule 12 and 13 deals with. Even though his plaint is rejected under Order 7, Rule 11, he can make either challenge that order or by way of appeal, or he can file a fresh suit on the same cause of action. That's why I said in the beginning, there are other provisions apart from section 11 of the Code of Civil Procedure, under which a party is prevented from filing a further suit. In one of the question papers in Uttar Pradesh civil judge examination, that question was asked. That's why I said it may be asked in our state also. Normally, what we will remember, section 11, we will remember res judicata. If the suit is subjected to res judicata, second suit dismissed as it was res judicata, or decided, a case has been decided and the party files one more case and the principles of res judicata are attracted in the second suit. Naturally, the opposite party will take up the contention. This is hit by res judicata. Second suit is hit by res judicata. Matter in issue should be the same. It should be directly and substantially, or collateral in issue. That is how they have bifurcated. Matter in issue, when it is directly and substantially same in the earlier suit which has been decided, then res judicata is applicable. If it is only collaterally an issue in the earlier suit, then res judicata is not applicable. To make it more clear to you, if a landlord files a suit for recovery of money for 3 years, 2019, 20, 21. He files a suit for recovery of money. Defendants take up the contention, tenant, I have already paid the amount. Court upholds the contention of the defendant, dismisses the suit. If the plaintiff, the landlord, files one more suit for recovery of money against the tenant for the same year, 3 years, definitely it is hit by principles of res judicata, because the matter in issue in earlier suit was directly and substantially the same. ಹಿಂದೆ ಹಾಕಿದ ಕೇಸ್ನಲ್ಲಿ ಇದೇ ವಿಷಯದ ಬಗ್ಗೆ ಅರಿಯರ್ಸ್ ಆಫ್ ರೆಂಟ್ ಬಗ್ಗೆ ಆ 3 ವರ್ಷಗಳ ಬಗ್ಗೆ ಇತ್ತು. ಡೈರೆಕ್ಟ್ಲಿ ಅಂಡ್ ಸಬ್ಸ್ಟಾನ್ಷಿಯಲಿ ಸೇಮ್ has already been decided. He cannot be permitted to agitate again. Collateral issue in a recovery of rent before a small cost. The court observes that the landlord is not an owner. Subsequently, the landlord files a suit. Tenant takes up the plea. No. The second suit is hit by principles of res judicata. In earlier small cause case court, the court has observed that he is not the landlord, he is not the owner. The courts have taken the view, no. Small cause court has no jurisdiction to decide the title of the property, immovable property. Incidentally, that has been considered the law. It requires independent inquiry to consider whether he is a owner or not, he has got title of the property or not. The competent court is civil court. So incidentally that has been. So that is will not attract the principles of res judicata. So this directly and substantial issue has been further bifurcated. One is when the matter is actually the same, the subject matter was actually the same in earlier suit. Innondu constructively the same. That is called as constructive res judicata. ಈ ಕನ್ಸ್ಟ್ರಕ್ಟಿವ್ res judicata ಸ್ವಲ್ಪ ತಲೆತುಂಬಿ. ಅದೇನಪ್ಪ ಅಂದ್ರೆ ಕನ್ಸ್ಟ್ರಕ್ಟಿವ್ res judicata means this relief was available to the plaintiff in earlier suit, but he has not sought for that. ಈ ಪರಿಹಾರವನ್ನು ಎರಡನೇ ಕೇಸ್ನಲ್ಲಿ ಹಾಕಿದಂಥ ಪರಿಹಾರವನ್ನು ಅವನು ಮೊದಲನೇ ಕೇಸ್ನಲ್ಲಿ ಕೇಳಬಹುದಾಗಿತ್ತು. ಆ ಕೇಸ್ನಲ್ಲಿ ಅವನು ಆ ಪರಿಹಾರ ಕೇಳದೆ ಇರೋದ್ರಿಂದ ಲಾ ಪ್ರಿಸ್ಯೂಮ್ಸ್ that he has sought for that relief and that has been refused. That is constructive res judicata. ಇದಕ್ಕೆ ಉದಾಹರಣೆ ಕೊಡಬೇಕು ಅಂತ ಹೇಳಿದ್ರೆ, there was a writ petition filed by a police officer challenging his termination. He challenged the termination on the ground before the High Court that he had not been given opportunity before he was terminated. ನಾನು ವಜಾ ಮಾಡುವಾಗ ನನಗೆ ಅವಕಾಶ ಕೊಟ್ಟಿಲ್ಲ. It is against to the principles of natural justice, therefore that has to be set aside. It is more important, principles of natural justice. The High Court, after considering the case and also perusing the records provided by the police department, found that what the petitioner says is wrong. He has been given sufficient opportunity, he has not made use of that, and court held that no, you have been afforded sufficient opportunity and dismissed the writ petition. Then the petitioner files a suit challenging the very same termination order on an additional ground, stating that no, I have been appointed by IGP, but whereas I have been removed by the additional IGP. I was appointed by the Inspector General of Police, but I have been removed by the additional Inspector General of Police. Therefore, by virtue of the service rules, he cannot do that. That order is not valid. Then the police canvass this constructive res judicata department. No. When he challenged this order before the High Court in earlier petition, this ground was available to him. Isn't it? This ground was very much available to him. He has not pleaded that ground. He has not raised that ground. Therefore, that amounts to constructive res judicata. That means he has given up that ground. Or he has sought for that ground, the court has refused that ground also. And so ultimately the Supreme Court upheld the contention of the police department and held that suit is not maintained. Suit was dismissed. That is the constructive res judicata. So like that, when such a case has already been decided, parties are not entitled to file one more suit because of section 11. But there are similar provisions under the Code of Civil Procedure both in order as well as sections. I will not go in detail about those provisions and just give you the provisions because of the time constraint which you can make use of. In orders, what are the orders under which a party is prevented from filing a further suit? You remember, you know, once I say you know I was going this. Order 2, Rule 2. Order 9, Rule 9. When Order 2, Rule 2 is invoked, saying that an earlier suit, he has not thought this prayer. Because Order 2 says, when you file a suit, you are required to seek for the entire relief for which you are entitled to on that cause of action. If you omit to seek for the entire relief for which you are entitled to on that cause of action, you are not entitled to file further relief for the relief which you have omitted in the earlier suit. Order 2, Rule 2. Order 9, Rule 9. When only the defendant appears, plaintiff remains absent, suit will be dismissed for non-prosecution under Rule 8. Order 9 deals with regard to consequences of appearance and non-appearance of the parties. When the suit is dismissed for non-prosecution or non-appearance of petition plaintiff, then Rule 9 says plaintiff cannot file one more suit on the same cause of action. Most dangerous. Only remedy available to the plaintiff when the suit is dismissed under Order 9 Rule 8 is to file a miscellaneous petition and seek for restoration under Order 9 Rule 9. Then comes Order 11 Rule 21, interrogatories. When the parties are directed to, plaintiff is directed to furnish or answer to the interrogatories sought by the defendant, and if he fails to answer those interrogatories questions, you have to ask interrogatories with the permission of the court. When the plaintiff fails to answer those interrogatories in spite of the court order, suit will be dismissed. Once suit is dismissed under that provision, he cannot file a fresh case. Very dangerous. Order 11. Then comes Order 21, Rule 3, capital A. Rule 3 deals with regard to compromise. Order 23, Rule 3. Order 23, Rule 3. Order 23, Rule 3, capital A I am speaking of. Where it says, if the suit is compromised, the parties are not entitled to file a suit challenging that compromised decree. They cannot file a suit. Further suit cannot be filed. Even Supreme Court has also taken the same view, and only remedy available to the parties to challenge the compromise to go before the same court. Same court. And Order 22 Rule 9. Order 22 is also one of the important provision for your examination, where it deals with regard to bringing the legal representatives on record. Rule 3 deals with regard to bringing the elders of the plaintiff, deceased plaintiff. Rule 4 deals with regard to bringing the elders of the defendant. So as we know that we have to bring the legal representatives on record within a period of 90 days as per the limitation time. Once the 90 days are over, suit is abated. There is no requirement by the court to pass any specific order for that. By presumption of law, law presumes, even though the date might have been given in the court for that case, but in the eye of law, if 90 days are already over, it is presumed that it is already abated. That is why, if the party has died, then you can file application, only one application within 90 days to bring his law. If it is already more than 90 days, then you have to file one more application for setting aside the abatement under Order 22 Rule 9. So that application for setting aside abatement has to be filed within 60 days after 90 days. 90 ದಿವಸ ಆದಮೇಲೆ 60 ದಿವಸ ಒಳಗಡೆ. If it is more than 150 days, 90 plus 60 days, then you have to file one more application for confirmation of delay under Section 5 of the limitation. But Order 22 Rule 9 says, if you fail to bring the laws on record and allow the suit to be abated, then the plaintiff cannot file a fresh suit on the same cause of action. That is the danger. Similarly, in sections also, I am mentioning some of the orders and some of the sections which you can go through. Akhanksha ಕೇಳಬಹುದು ಪ್ರಶ್ನೆ ಏನು? Apart from section 11 of the Code of Civil Procedure, what are the other provisions under which a party is prevented from filing a further suit? All these all provisions we have to write. In sections 11, we are familiar with. So where section 10 ends, 11 starts. Section 10 deals with regard to stay of suit or res sub judice. Where a suit has already been filed, the difference between the 10 and 11 is, in section 10, two suits should be pending. Whereas in section 11, one suit should have already been decided, only another suit is pending. Then res judicata. If both the suits are pending, section 10, stay of suit. So suits, you should remember, suits should be pending. And what it says, the latest suit, second suit, the proceeding should be stayed. Not dismissal, only proceeding shall be stayed. If you allow both the cases to be tried, then there is a chance that conflicting judgment will be given. Which judgment you are going to take? So that intention they have made, one of the intention of course, between the same parties pertaining to the same subject matter or persons claiming through them. If one suit has already been filed and another suit has been filed now, and in the earlier suit, the relief which is claimed in the second suit can be sought. ಆ ಕೋರ್ಟ್ನಲ್ಲಿ ಆ ಕೋರ್ಟಿಗೆ ಅಧಿಕಾರ ಇರಬೇಕು. ಈ ವ್ಯಾಜ್ಯದಲ್ಲಿ ಏನು ಕೇಳಿರ್ತಾನಲ್ಲ ಪರಿಹಾರ, ಈ ಪರಿಹಾರ ಆ ಕೋರ್ಟ್ನಲ್ಲಿ ಕೇಳಕ್ಕೆ ಅವನಿಗೆ ಆ ಕೋರ್ಟ್ಗೂ ಅಧಿಕಾರ ಇತ್ತು, ವ್ಯಾಪ್ತಿ ಇದ್ರೆ, then only section 10 is applicable. Then the court has to say the proceedings in the second suit, later suit. ಅಲ್ಲಿ ಒಂದು ನಮ್ಮದ್ರಲ್ಲಿ ಆಯಿತು ಕೇಸ್ನಲ್ಲಿ A suit for partition was filed pertaining to one property. When it was pending before the Supreme Court, another suit was filed by one of the co-partners pertaining to other properties, including the suit property in this appeal pending before Supreme Court. ಅದನ್ನು ಸೇರಿಸಿ ಕೇಸ್ ಆಗುತ್ತೆ. Ultimately, the appeal was ended in compromise, and then FDP was filed. So when the FDP was pending, in the suit the plaintiff filed an application after several years under section 10, stay the further proceeding of FDP. So rightly the court held that it has already been attained the finality. There is no suit is pending. Compromise has been made. Only FDP is there. Therefore, there is no question of application of section 10. Application was dismissed. So that is how we have to deal with regard to stay of suit or res sub judice, section 10, res judicata 11, and other provisions under which a further suit cannot be filed. That is section 21 capital A. Yesterday I have told you that, where the defendant fails to raise the objections with regard to the territorial jurisdiction at the earliest point of time and allows the suit to be decreed, then the defendant under section 21 capital A cannot file a suit challenging the judgment and decree on the ground the court which passed that decree was not having the territorial jurisdiction. Suit bar, section 21 capital A. Then comes section 47. 47 says all the questions, disputes arising in an execution petition has to be decided in the execution court, by the execution court itself. You cannot file a separate suit. All questions arising in an execution petition has to be decided by the executing court only. And parties are not entitled to file a separate suit with regard to that point. Section 47. Then comes section 95, where the plaintiff obtains an order of TA or ABJ under section R38, Rule 1, arrest before judgment, Rule 5, attachment before judgment, on false grounds, misleading the court, the defendant can claim compensation. If he satisfies the court, because it harms the reputation of the defendant, especially ABJ, attachment before judgment, especially in business community. If you go and attach the properties or goods in the shop, his future is doomed. Nobody will come forward to give him credit. It harms him very much. So he can claim compensation, damages. Unfortunately, section 95 says, if he wants to invoke section 95 to claim the compensation or damages the defendant, he is entitled only for 50,000. Earlier it was still less, no kadame ittu. 2002 nalli adunu jaasti madidru. So the lawmakers have assessed the reputation of the people at 50,000. After he should be satisfied. On Maryada for 50,000. He might have lost lakhs of rupees. But once he invokes section 95 of the Code of Civil Procedure in seeking the compensation, that is the maximum. Not necessarily the court should grant only 50,000 only. It can also award less, but maximum 50,000. 95 says he cannot file a separate suit if he is not happy with the compensation. Suit is barred. If he wants to claim more compensation than 50,000 rupees, then he cannot invoke section 95. He should go for filing a suit directly. Once he section 95 use madda, doors are closed. He should accept my reputation is only 50,000. Then comes yes. So these are the few provisions under which a party is prevented from filing a further suit. A question may be asked to you. So now coming back to our earlier point where we have examined section 115, if you remember, revision. Now, reference 113, review 115, coupled with order 46 and order 47. Reference lies only to the High Court. Please remember reference under section 114, revision under section 150, second appeal under section 100 lies only to the High Court. No other. To invoke section 13 reference, the court should entertain a doubt, the party should entertain a doubt with regard to the validity of regulations, rules or provisions of any law. In a suit against which an appeal is not provided. Appeal ಇರಬಾರದು ಅಂತ ವ್ಯಾಜ್ಯದ ತೀರ್ಪಿನ ಮೇಲೆ. Condition number 1. Second one is they should entertain a doubt with regard to the validity of any provision, regulations or rules or notification. Then only the court can refer that to the High Court. It does not mean that the court should stop and wait the report or the decision of the High Court. It can continue the trial. In the High Court, when it is referred by the trial court, if it is pertaining to a state enactment, the High Court has to hear Advocate General also, apart from the parties. If it is pertaining to a central enactment, then the High Court should also hear the Attorney General who represents the central government. Then the High Court has to give its opinion and send it back to the trial. That is reference. As far as review is concerned, there should be an error on the face of the record. One of the main grounds for entertaining a review under Order 47 coupled with Section 114. Revision is order. As one tier common. It is alone. Only reference has got companion of Order 46, 113. Review Section 114, companion of Order 47. So the review power is very limited. Now, unlike an appeal power, where the appellate court has power to examine everything, especially first appeal. Facts will also be examined, evidence will also be examined by the court, both documentary or oral. But review will be very limited. If there is any error on the face of the record, the parties can invoke Section 114 or Order 47 coupled with Order 47, but that has to be filed within 30 days. Of course, you invoke Section 5 of the Limitation Act also if it is more than 30 days. To which court the review has to be filed? To the court whose order you are seeking for review. ಯಾವ ನ್ಯಾಯಾಲಯದ ಆದೇಶದ ರಿವ್ಯೂವನ್ನು ಕೇಳ್ತಾ ಇದ್ದೀರೋ ಅದೇ ನ್ಯಾಯಾಲಯಕ್ಕೆ ನೀವು ಅರ್ಜಿಯನ್ನು ಸಲ್ಲಿಸಬೇಕು. So only if the party makes up a case, there is an error on the face of the record. Court has failed to consider this document even though it has been produced. Suit for recovery of money has been filed. The defendant has taken up a contention. I have already paid 20 lakhs out of 50 lakhs claimed by the plaintiff. And he has produced the acknowledgement. The court overlooks, without considering that acknowledgement, has proceeded to pass the decree for 50 lakhs. So he can seek for review. There is an error on the face of the record. I have produced the exhibit so and so, P5, acknowledgement, which has been admitted by the plaintiff also. Please review your order. The court has got that power. So that is how we are dealing with regard to the reference 114 coupled with 46, review 114 coupled with 47, revision section 115. These are the few problems. I think